beneficial for us to have a trust that is governed by the laws of the Cook Islands or Cayman Islands or any other sort of islands out there or any other nation? Well, once we provide in the trust that it's governed by the laws of the Cook Islands, the odds are it will be those laws that apply to the trust with some narrow exceptions. And what is the benefit of the laws of a country like the Cook Islands? Well, the Cook Islands in 1989 have gone through a significant modification of their trust laws. And they've introduced a lot of asset protection oriented features into their trust law. For example, and probably the most important feature of all of this, is that the Cook Islands does not recognize foreign judgments if they somehow relate to a trust. There are very few other countries like that, other than the Cook Islands. Nevis in the West Indies is one of those countries. St. Vincent and the Grenadines, also in the West Indies, is one of those countries. And I'm struggling to recall if there are any other countries, could be just these three, that will not recognize a foreign judgment if it somehow pertains to trust. So think about it. Our client is being sued in New York. The plaintiff gets a judgment against our client in New York, starts looking for our client's assets, finds out that all of the assets have been transferred to a trust in the Cook Islands. Plaintiff says, you know what, that's not a problem. There is enough money here at stake where I will fly to the Cook Islands with my New York judgment and go after the assets of the trust. So the plaintiff gets to the Cook Islands after spending a few hours on Google Maps trying to find them with their New York judgment, goes to the court in the Cook Islands, says, hey, I have a judgment here from the state of New York in the United States. Can you please enforce this judgment in the Cook Islands? And the court will say, well, generally we will enforce a judgment from a foreign country. We signed the Hague Convention of 1972. We recognize foreign money judgments. But you know what? When it pertains to trust, we do not. So your judgment from New York is no good here. If the judgment from New York is no good in the Cook Islands, what can the plaintiff do? Can the plaintiff file a lawsuit against our client in the Cook Islands? No, they cannot. Why? Because our client does not live in the Cook Islands. Our client did not sign any contracts in the Cook Islands. There's no accident that took place in the Cook Islands. The court in the Cook Islands will have no personal jurisdiction over our client. So he cannot be sued in the Cook Islands. What is left for the plaintiff to do? Well, there is really only one thing that they can do. They can go to the Cook Islands and simply argue that the transfer of the assets into the Cook Islands Trust was a fraudulent transfer. Remember those fraudulent transfers we've talked about a couple hours ago? Well, they can go to the Cook Islands and argue there was a fraudulent transfer. Do you guys think that the Cook Islands makes it difficult or easy to argue a fraudulent transfer? How about the fact that in most cases there's only 1 year statute of limitations for a plaintiff to bring a fraudulent transfer action? 1 year from the day you fund the trust, the plaintiff has to come forward and challenge the transfer of the assets into the trust. The lawsuit is filed against our client in the United States. Our client settles the trust in the Cook Islands. How much time passes before the lawsuit here is concluded? 1 year, 2 years, 3 years? Certainly more than 1 year in almost all cases. Let us say that somehow, miraculously, the plaintiff gets to the Cook Islands within that 1 year. In the Cook Islands, they will have to prove a fraudulent transfer beyond a reasonable doubt. And they will also simultaneously have to establish that the client was insolvent at the time of the transfer. Establishing a fraudulent transfer beyond a reasonable doubt it's a criminal law standard. It has never been done. Okay? So what can the plaintiff do? Can't sue the client in the Cook Islands. Fraudulent transfer attack is extremely unlikely to work. To my knowledge, it has never once worked before. So what can they do? Well, if the plaintiff is smart, the plaintiff is going to go to the local judge, here in the United States, and say, Your Honor, do something to help me get the assets out of this living trust, out of this foreign trust. What can the judge do? Well, in some cases, and there are about 5 or 6 court decisions out there, the judges have said to the debtor, bring your assets back from your Cook Islands Trust, and if you do not, we are going to hold you in contempt of court. Sounds scary, because if the client is held in contempt of court, they get to sit in jail until they bring the money back from the Cook Islands. There have been thousands upon thousands of trusts set up in these various offshore asset protection jurisdictions, and we have about 5 or 6 cases of contempt. So statistically speaking, it's certainly not something that I worry about. Practically speaking, I never worry about it, for one important reason. All of these contempt cases can be traced back to a very poorly structured asset protection plan, or to a very poorly drafted asset protection trust. For example, the most famous case of all, the Anderson case. The Andersons were this lovely couple in San Diego, set up a Ponzi scheme, and they bilked some elderly investors out of something like $30 million of assets. The assets go into Cook Islands Trust. Eventually the Andersons get discovered, they're indicted, and now the Federal Trade Commission is going after the Andersons, and they're saying, give us the money back. Where is the money? Well, we put the money into Cook Islands Trust. The FTC goes crying to the judge, and the judge says to the Andersons, bring the money back out of your Cook Islands Trust. At the time the judge orders the Andersons to bring the money back, the Andersons are acting as the trustees of their own trust. Why are they doing that? I think they're trying to save their $1,500 a year that they would have to pay to a foreign trustee. Idiotic, but they were doing that. They were the trustees of their own trust. And because they were the trustees of the trust, when the judge ordered them to bring the money back, they could have done that. And they didn't. They resigned as the trustee, and the backup trustee was appointed as a trust company in the Cook Islands. So the judge calls the Andersons back to court and says, did you bring the money back? Nope. Why not? Well, we are no longer the trustees of the trust. But when I ordered you to bring the money back, weren't you the trustees? Yes. Off to jail you go for contempt of court. And you will stay in jail until you get the money out of your trust. The Andersons find themselves in jail, and with the prospect of sitting in jail indefinitely. So what do? They start sending letters to the trustee on almost a daily basis. You know, we're sitting here in jail, we have a cellmate named Baba, we don't like Baba, please get the money out of the trust so we can get out of jail. What does the trustee do with all of these letters? Do they respond? Do they say, here is the money, get out of jail? The trustee simply ignores all of these letters. Why? Well, first of all, the trust provides that once what's called a duress event has taken place, the trustee is forbidden from making distributions. But more importantly, for the trustee, under the laws of the Cook Islands, once a duress event has taken place, if the trustee makes a distribution out of the trust to the beneficiary, the trustee will automatically lose their license in the Cook Islands, and they will not be able to operate as a trust company. So as you can imagine, the trustee simply ignored those letters, and the money stayed in the Cook Islands Trust. After about 6 months of this, the judge is now convinced that the Andersons really cannot get the money out of their Cook Islands Trust, and which means there is no reason to keep them in jail, and the Andersons are released. When this case originally came out, and for a few years after that, a lot of people have come forward and said this is the end of asset protection planning as we know it. Because who will, in their right mind, do this if there is a threat of going to jail for contempt? Well, in a well-run law office with lawyers who know how to do this work, this can never happen, because you simply do not draft trusts like this. You do not allow clients to act as their own trustees. You make sure that the client retains no control over the assets of the trust so that he cannot be held in contempt of court. And at the end of the day, based on the relationship that the attorney may have with the trust company, you can always force the trustee to bring the money back here to get the client out of jail. But more importantly, and I think more importantly, none of these commentators, when the Anderson case came out, seemed to inquire as to, did the trust really work